Hello, welcome to the fourth of the Summer of Law webinars being run by Kent Law School. The aim of these webinars is to offer a taste of the legal topics you can study in a law degree at university, and also to give you an insight into the distinctive, critical approach to teaching law in Kent Law School. There's a playlist online of previous webinars available on our YouTube in the Kent Law School channel. We're very pleased that you're able to join us today for this session on Can Employment Law Cope with COVID? Okay, so I'm Diamond Ashiagbor and I'm Professor of Law in Kent Law School. I teach on the Employment Law module at undergraduate and postgraduate level, and I convene that module. I'm going to hand it over now to Professor Lydia Hayes.
Hi, I'm Professor Hayes and I'm head of Kent Law School. Both Diamond and I teach and write about employment law, which is often called labour law because it's all to do with work or labour. And that obviously is a big part of almost everyone's lives. Our session uses slides and text with images. The webinar is interactive. So please use the chat function to share your views. We really welcome your input and we're going to be asking you some questions as we go through. Now, only Diamond and I can see your responses. So please, there's no need to feel embarrassed or shy. And if we mention something that you've put into the chat, we won't use your name. So Diamond, could we start with you describing what employment law is and what it's got to do with COVID?
Okay, so employment law comprises a rich array of obligations, responsibilities and rights that govern the world of work. And it began in the days, centuries ago, known as master and servant law. But in modern times, work is governed by statutory rights that balance dignity and human rights of the worker with the commercial interests of employers. So statutory rights are those created by Parliament, decided by politicians and governments, set out in Acts of Parliament. But employment law is also about contracts of employment, so that's agreements between the worker and the employer, and it's about rights such as things like wages, holidays, equality, that Parliament has designed to be relevant in situations, all types of employment situations, all kinds of workplaces and working relationships. But employment law has come under the spotlight in new ways during the pandemic, and that is what this webinar will focus on. When the pandemic hit, UK employment law provided protection from COVID for some workers, but has been ineffective at protecting others. The workers who are the highest risk of exposure to the virus work in occupations with the lowest access to legal protection in their work.
It's really interesting, Diamond. And I wonder, perhaps that sounds a little strange to participants to in some ways think that employment law can protect from COVID, because staying safe from COVID is about very practical matters. So I'd like to start with a question to our participants. If you could move the slide on, Diamond. Thank you. I wondered, participants, can you put in the chat, what are the things or actions or behaviours that keep people safe from COVID? There's some responses coming in now. Thank you. Yeah, several people have put masks, social distancing, being able to follow COVID guidelines, face coverings, being able to work from home, sanitizing, washing your hands. Interesting here, protecting your finances. And is that what employment law does, right? Being hygienic, having a vaccination. Yeah, so Diamond, all these sorts of things, they're the practical things to do with staying safe from COVID. So can you tell us a bit about what that's got to do with employment law? Oh, somebody's also put personal protective equipment, PPE.
That's a good one. Yes, definitely. Okay, so many of these issues, wearing masks, having accessibility to wash your hands at work, having enough money, somebody mentioned finances in the chat, having enough money to choose whether to take, that you can take time off work, or whether you can take certain kinds of transport, like take the bus or drive your own car, being able to plan your day, being able to have sick pay if you need to self-isolate. These are things which are set out in employment rights or are closely connected to employment rights and employment law. But we find that certain groups of workers, for example, women, Black workers and young workers, are most likely to work in jobs where there are fewer employment rights available to protect things like access to sick pay if you need to self-isolate at home. We know from data about COVID that many of these jobs expose workers to higher risks of catching COVID. So there is a connection between lower levels of legal protection in a job and higher risk of exposure to coronavirus. So in addition to everything you said in the chat about staying hygienic, being in small groups of people, vaccinations, employment law is also relevant in the background and in the foreground of enabling people to be protected from COVID.
So that suggests that we need to explore how employment has been designed by the lawmakers and how it's applied, so that we can come up with an explanation about how lack of employment protection might be putting lives at risk. Now, if we look at the design of employment laws, the law that governs employment rights and rights at work was developed at a time when the manufacturing sector was dominant. So the 1960s, 1970s, and into the 1980s and 90s, with many workers being employed in industry during the 60s and 70s, when employment law was its sort of foundational time in a modern sense. And in those days, most jobs were stable. There were jobs available that were full-time with fixed or predictable hours of work, and they were considered permanent. Legal protections, such as the right not to be unfairly dismissed from work or the right to receive sick pay, they aren't granted to all of those who are engaged in work. Those workers who fit typical or that standard pattern, they're known in law as employees, and they receive the most comprehensive suite of legal protections and protection of their human rights. So the right to be not unfairly dismissed, statutory minimum wage, sick pay, holiday pay, protection from discrimination, parental leave rights. Now, somebody's put a really interesting comment in the chat about back in the day in the 60s and 70s, we didn't have equality. We didn't have equality laws. And that's a really, really significant point. It's really correct. It certainly was the case that equality laws weren't active in the field of employment when those rights were originally designed. So even before COVID, this sort of pattern of work around the idea of a stable, permanent, full-time job, this is disintegrated. There are fewer and fewer people who are legally classified as employees, and more work is now part-time, or it's 0 hours, or it's casual or fixed term or temporary. And workers are now much, much more likely to be working for multiple employers or directly employed, indirectly employed, considered to be self-employed. And examples of these kind of newer, more flexible patterns of work are particularly apparent in, for example, the care home sector, where instead of being directly employed by a hospital or a nursing or residential home, workers might be assigned to work shifts at different places of work, or in the private homes of clients, and they'll be assigned by an employment agency rather than directly employed. And that's a really strong feature of the modern labour market. So, Diamond, Could you say a bit about what that's got to do with the health of workers?
Okay, so even before the pandemic, even prior to the pandemic, we can identify major inequalities and disadvantage in access to work and employment rights, and that's connected to inequalities in health and housing. In 2010, a major report commissioned by the government, the Marmot Review, found that there were major health inequalities in the country which are linked to employment. The Marmot Review study showed that people living in the poorest neighbourhoods in England will on average die 7 years earlier than people living in the richest neighbourhoods. But it's not just earlier death. People living in poor areas not only die sooner, but they spend more of their lives with disability or ill health, on average, a total difference of 17 years. So these health inequalities arise from a complex interaction of many factors, such as poor housing, education, occupation, income, social isolation, disability, but all of these factors are strongly affected by a person's economic and social status. So what that means is insecure and poor quality employment is often associated with increased risk of one's physical and or mental health worsening from conditions caused by work that in turn lead to absence due to illness and worklessness. So these adverse working conditions further damage health. People's health can be damaged at work by factors including exposure to physical hazards, physically demanding or dangerous work, long or irregular hours, working hours, shift work. So think of the examples Professor Hayes has just given about the growing flexibility of work, the shift away from stable permanent hours. So a lot of health inequalities are exacerbated by the way in which patterns of work have changed over the decades. In addition, technological advances and the fact that markets are more globalized, that means we buy products made in other parts of the world, we sell products and services to the other parts of the world. So for example, television is a service that we sell, education is a service that we sell to other parts of the world. So that's an example of work being more globalized. That means new types of work, new tasks such as information processing, service centers have developed, and that's led to demand for greater flexibility of employment arrangements, greater flexibility of contracts, and that's often combined with less job stability and less security, as well as more intensive work and longer hours. So bringing that all together, the Marmot Review found that the most deprived workers, especially those in what are known as precarious jobs, where there's a lack of safety or low wages or high job instability, those more precarious workers are more likely to have psychological or physical health problems, such as depression, cardiovascular disease, heart disease, musculoskeletal disorders.
Yeah, so that means that in some jobs, people are in particular need of legal rights. That's a lot of what the Marmot Review tells us about connections between employment and health. So those legal rights, they need them to protect them from the factors that you're talking about: low pay and uncertainty and insecurity and long hours and accidents, or physical and mental stress. Now, someone's put an interesting question in the chat, which is about whether employment rights strengthened when we joined the EEC, or the European Union. That's a really good question, because when we joined the EEC, the EU, it did have an impact in terms of legal rights at work. That was particularly around issues to do with equality. Holiday entitlements considerably improved because of rights that developed through the EU, and also health and safety. That's certainly true. However, membership of the EU and a lot of the making of regulations and directives in the EU hasn't had a follow through in terms of how wages are paid. Issues to do with wages and minimum wages are dealt with at a domestic level in the UK, and also not significantly on issues around contract. So we see differences in different member states around sort of norms around how workers are contracted. And in the UK, we have a tradition of very high rates of temporary agency work and 0 hours contracts in a way which is earlier and more embedded than elsewhere in the EU, but it's a really, really interesting and important point to have made. Thank you. So, Diamond, can you explain how it is that in the UK, employment rights attach to some jobs, but not to others? How does that happen?
Okay, so the UK labour market is characterised by flexibility, and the terms used to describe this include terms such as the gig economy or non-standard work. Another example of flexible work would be agency work. So individuals and businesses are free to agree the terms and conditions that best suit them. And this is a strength as well as an obvious risk. In particular, some employers might use this flexibility to transfer risk to the workers or to exert control over the workers. Workers who are not classed as employees, but known as workers, are entitled to very few employment rights. And we've had a really good set of questions in the chat. One is asking, how will employment law change now that Brexit has happened? And another is asking, is explaining that somebody's particular experience of working during COVID and being in a company where they were made redundant. Okay, so I'm going to try to bring those issues into the chat, into the discussion here about legal design and job design, and this question about those people who aren't classified as employees being entitled to very few employment rights. So on the one hand, being able to work when you want is a good thing. Being able to have choice is a good thing. But not knowing whether you're going to have work from one day to the next when you still have bills to pay isn't such a great thing. So a really powerful, one of the most extreme examples of that sort of flexibility is the 0 hours contract. And some of you may have heard of that. Some of you may be working on 0 hours contracts, even though you might not necessarily have that label attached to your job. So 0 hours contract is where an employer isn't obliged to provide a minimum number of hours a week or a month or a year. And that could be seen as an extreme example of one-sided flexibility. So where a worker doesn't have any guaranteed hours, that means they can be offered work at the discretion of the employer, or perhaps at the whim of the employer. They can face irregular shifts and therefore irregular income. So rather than pick and choose their hours, many workers feel compelled to work whenever asked. If they turn down a shift, there's an implicit threat that they might lose any future work. So just to come back to those questions in the chat about the impact of Brexit and experience of redundancy. So as Professor Hayes said, some employment rights were enacted in the UK because the UK was a member of the European Union. For example, some equality rights and some rights to be protected even if you're a flexible worker, like if you're a part-time worker. Those rights are crystallised. They are now sort of entrenched into UK domestic law, which means they stay on the statute books, they stay as rights until the UK Parliament decides to repeal them. So what Brexit means is that all those rights that people had as workers in 31st December 2019 still existed 1st of January 2020, but the UK government is now free to get rid of those rights, such as equality rights and protection when there is mass redundancy. So it just means potentially the UK government can get rid of some of the employment protection rights, especially the ones that employees had, but some of them workers also have. And somebody asked this question, would I describe 0 hours contracts as non-reliable? I suppose perhaps one way to think about it is that they can be unpredictable. So if you work in hospitality, assuming there's not a pandemic, and the hotel you're working for has a wedding and also a 40th birthday party, then you might be called in because there's extra need for extra shifts. But if there's a quiet period, then that's it, you're sitting at home. So they're unpredictable, and it means you don't necessarily know that you'll earn enough each week to pay your bills. Okay, so what I want to ask you now is to ask you a question, digging a bit more deeply about insecure work or 0 hours contracts. Maybe you've worked in a job where your hours are uncertain, or you know someone who is on a 0 hours contract. What type of job do you think, what kind of jobs do you think are most likely to be organised as 0 hours jobs or insecure jobs. So please make use of the chat feature to share your thoughts.
So yeah, while people are putting in some ideas about what type of jobs people do that might be insecure jobs, we could just pick up on a question that somebody's asked about whether 0 hours are really useful because they help small companies and startups when they are kind of not sure about income coming in. I think that's a good point, because it helps to highlight that most of 0 hours contracts are with some really, really big employers. So when we think about organizations such as Amazon, their delivery drivers, Deliveroo, for example, when we think about the care home sector, these are multi-million, billion-pound industries that are utilizing 0 hours contracts. So that is, one of the reasons why it affects so many different workers. So there are some great comments coming in here. Receptionists, warehouse workers, agency workers, hospitality workers, cleaners, in the events industry. So yeah, we've got a few people who work in the events industry that have made comments here about working on 0 hours contracts, security workers too. Yeah, so you see a very broad range of jobs within the UK economy that we associate with 0 hours contracts coming in, examples coming in their Diamond. What do you think that the problem is with these kind of contracts from an employment law perspective?
The difficulty of these jobs from an employment law perspective is that they don't look like the traditional, stable, full-time, regular jobs that employment law was originally designed to fit and to protect. So a problem at a practical level is that there's flexibility for the employer, but not for the worker. And that makes it almost impossible for workers to plan their finances, as I've mentioned, but actually also makes it really difficult for workers to plan their time. That's a particular issue for parents who need to arrange childcare, which can often be expensive. It can also be very difficult for others with care responsibilities if they can't predict their time. As far as employment law is concerned, the issue also is that the law doesn't recognise 0 hours contract work as regular work, and so those workers are excluded from many employment rights, such as the right to sick pay, holiday pay, or protection from dismissal. Now, the number of people employed on 0 hours contracts, we've seen all these different categories people have mentioned in the chat: agency work, warehouse work. The number of people on 0 hours contracts has increased rapidly over the past decade, and it's currently about 1 million people. Bearing in mind there's about 25 million people in paid work at the moment, and some of those people are entrepreneurs, they run their own businesses. So those 1 million 0 hours contract workers are extremely vulnerable when there's an economic downturn, economic shock, because it's easiest for employers to reduce their hours or stop them completely. So the risk of a downturn has been transferred from the employer to the worker. So think about somebody who might work in a permanent or secure job, for example, I don't know, a hospital radiographer. If there's a period of time when there are fewer people coming into the hospital to be x-rayed because the hospital is focusing on COVID patients, the hospital doesn't make radiographers redundant. It puts them onto something else. So the risk of there not being that job for you isn't carried by the worker. Whereas if you're on a 0 hours contract, the employer will just say, there aren't customers coming in, we're going to have to let you go or reduce your hours. So the risk of a downturn with 0 hours is transferred from the employer to the worker. But these workers are also vulnerable if there's a health crisis. Lydia, can you make any connections between the design of jobs and the workers who are most likely to occupy those types of jobs?
Okay, so this is about connections between job design and inequality, because work which is insecure and low paid and those jobs that you've talked about, Diamond, where they're sort of vulnerable to economic downturn, they are disproportionately jobs that are done by young people and by workers from Black and minority ethnic backgrounds. So the figures that lie behind this are that Black and minority ethnic workers are more than twice as likely to be stuck on agency contracts than white workers. So stuck on, meaning they don't really want to be on agency worker contracts. Black and minority ethnic workers are much more likely to be employed on 0 hours contracts. So we see 1 in 24 BME workers on 0 hours contracts compared to 1 in 42 white workers. And that will say something about the areas of the economy where Black and minority ethnic workers are employed. Now, for white men, only 2.5% of them are on 0 hours contracts compared to 4.1% of Black and ethnic minority men. So almost twice as many. The highest proportion of 0 hours contracts are found amongst Black and minority ethnic women, which is 4.5% of them compared to 3.2% of white women. So we see that it's being a woman makes you more likely to be on a 0 hours contract, and being a Black woman, a minority ethnic woman, makes you even more likely to be on a 0 hours contract. So again, these kind of figures are also seen around workers being on temporary work. So 1 in 13 Black and minority workers are in temporary work compared to 1 in 19 white workers. So millennials, so people who were born since the year 2000, millennials who are from Black, Asian and minority ethnic backgrounds, young workers, are at greater risk of being in unstable employment than their white peers. They are 47% more likely to be on 0 hours contracts and have a 10% greater chance of being in a second job. So that's telling us something about how they meet their economic needs. They need to have more than one job. They're more likely to be in that situation. BME millennials are also 5% more likely to be doing shift work and are 4% less likely to have a permanent contract than white workers. So here we are seeing the disadvantage of being younger combined with the disadvantage of also being from a Black and minority ethnic group. And so these figures are gathered by organizations like the TUC, the Trade Union Congress, who do research about the proportion of workers who are more likely to be trapped in insecure work. And these figures come from a TUC report in 2019 and also research which was published in June of this year. So it's very up to date. We see how these connections between inequality and being a member of a particular group connects to insecurity at work, Diamond.
Thank you, thank you. So what we've looked at so far is that the way in which some jobs are designed makes it more likely that workers will experience health detriment and disadvantage in the labour market. We've also explored how the design of the law means that in those jobs, legal rights are less available or they're harder to enforce. What you've also added is that jobs with less legal protection and higher health risk are more likely to be done by Black, Asian, minority ethnic workers and by young workers. So now let's turn specifically to the pandemic. And I have a question for our participants to answer in the chat. If you think of the conditions of the pandemic, what changes COVID-19 has just forced upon us all, and the things we need to do to stay safe, what rights do you think workers are most in need of during a pandemic? So please use the chat to share your thoughts. Okay. getting quite a few people saying sick pay, the right to sick pay, the right to leave, the right to have a period of leave with pay. So all around the same issue. Workers need a steady wage, as there's been an increase in poverty due to the pandemic. That's certainly been the case that some of the people that Lydia was talking about in the previous slide who were having to do more than one job, if those jobs were both in hospitality, then they are definitely exposure to increased poverty. The right to work in a safe environment, or the right to keep their role or to be offered something else. So even if your actual job isn't possible anymore, for example, because you work in a cinema and the cinema's closed because of lockdown, the right to be able to go back to that role once the cinema reopens. Rest breaks. To not be fired without cause. Lots of really good examples. Right to healthcare. So that's really interesting. In the UK, the right to healthcare isn't absolutely, you don't have to have a job to have a right to healthcare. In other jurisdictions, and for example, in the US, most people have a right to healthcare through their job. But there definitely is a connection between employment and healthcare, in that certain kinds of jobs mean you're going to be in greater need of certain kinds of health support afterwards. Gender equality. So that's interesting. That's a really interesting response that someone had said in the chat, that equality rights are more important in a pandemic. And I think that's something we're going to turn to later. Okay, really, really great set of responses. Thank you. So Lydia mentioned earlier the Trade Union Congress, the TUC, which represents 7 million workers across lots of different, who are members of lots of different trade unions. And one of the things they do is research. For example, they interview and ask questionnaires of workers saying, what do they really want? What's important to them? And in particular, what is it that workers who are on flexible contracts want? So all workers, whether they're on standard contracts or 0 hours contracts, deserve the same rights at work. However, studies show many non-standard workers, many of those workers on 0 hours contracts, lose out on the rights that are important to them and which other workers, those who are classified as employees, take for granted. Non-standard workers, those on 0 hours contracts in particular, are excluded by statute from dismissal protection. So that was one of the rights that people mentioned in the chat. The employment right in the statute not to be dismissed without due cause, that does not extend to those on 0 hours contracts. In addition, a substantive majority, 82% of those on 0 hours contracts, said they don't receive sick pay when they need to take time off for illness. 63% don't receive maternity or paternity pay. 70%, 7 in 10, don't receive redundancy pay if they lose their job or if they're made redundant. And just under half, so they don't get any holiday pay. Just over half, 54% of those on 0 hours contracts, said they don't get written statement of terms and conditions. They don't actually know what it is they're meant to be doing.
It's interesting too, isn't it, how in terms of the right to protection from unfair dismissal, that has, in recent years, the entitlement to that has increased from having a year's service to having 2 years service. And so even for workers who are not on 0 hours contracts that do have that right in theory, in practice, when it's come to the pandemic, if a worker doesn't have 2 years service, then it is very easy for an employer to dismiss them because they don't have the length of service entitlement. So there's a complex interplay between social factors like how long you've been able to stay in your job, how secure your job is, and how likely you are to be able to access protections in law. That's very interesting about the rights that are most important during the pandemic from the perspective of workers. I have another question here for participants. which is about, from your experience, your friends, what you've seen on the telly, your family, your neighbours, which groups of workers and in which jobs have been most affected by COVID, do you think? If you could put your comments in the chat here. Okay. So yeah, we've got restaurant workers. Obviously, restaurants have been shut down. Many workers have lost their jobs. Healthcare workers, workers for the NHS, retail workers. Yes, retail is an area with many workers in the UK, many of them on insecure employment and low wages. Again, restaurants, waiters, waitresses, hospitality industry, small businesses that are considered non-essential according to the guidelines, anyone working in jobs associated with events, security workers, bus drivers, taxi drivers, Uber drivers, people saying obviously anybody who works for a daily wage, people on public transport, shopkeepers, as you said earlier, Diamond, people who work in cinemas, jewelers, yes, obviously that's would be considered to be non-essential, and often small businesses, airport workers, education workers, construction industry, hairdressers. Construction industry and hairdressers are another example of work where workers can actually quite often be formally, legally designated as being in self-employed work, even though we wouldn't actually socially recognise their work as being self-employed, and so fall outside the protection of employment altogether. People working in airports, yeah, lots and lots of examples here. We find that workers who were at the highest risk of exposure to the virus, so many of those occupations that you have highlighted are people who have had been affected by the virus because of its economic impacts, but also there are workers who've been most affected by the virus in terms of their potential exposure to the virus. And there is a strong connection between those workers and those who work in occupations with the least access, the weakest access to legal protections in their work, which is either because the category of work that they're in, the rights don't apply to them, or because of things like, even though they might have the right, they haven't been in the job for a long enough period of time, or it may be much harder for them to actually assert their rights because they're on low wages and in insecure work, so they feel quite vulnerable to make a complaint. That is another issue. So where we see this connection most is particularly serious, where obviously we can connect mortality rates, so death rates from COVID, to particular types of occupation. And where that's highest is where workers have been in public facing occupations, because we know it's a socially transmitted disease, which is, the virus is very aggressive where people are in close contact with one another. So that means that we've seen high mortality rates among manual workers working in processing plants. So particularly, I think it's been on the telly quite often, where there have been outbreaks, particularly in meat processing plants, and in other areas where workers are manual and they are in close proximity to one another. For machine operators, so people who work on assembly lines or with agricultural machinery, health and social care workers, including home carers and residential care workers, security guards, transport workers, so bus and taxi drivers. During the first wave of the pandemic, bus drivers and taxi drivers, amongst men, that occupation was where men were most likely to die from COVID, was men who worked in the bus and taxi driver occupations, and also sales and retail assistants. Now, we've had several of the participants in this panel mention issues to do with gender equality. So I think it's interesting and important to note that men comprise the majority of critical care cases from people who have had COVID and ended up in hospital. But women are disproportionately affected because when we think from an occupational point of view about the majority of health and care workers and low paid workers are women. So the Office of National Statistics has shown that men in certain low paid occupations with frequent and close interaction with others are at a greater risk of exposure to the virus, and also that ethnic minority workers are overrepresented in these roles. It's also particularly for workers over 55 who are more likely to work in some sectors which are high risk sectors, such as social care, and disabled people who already have big challenges to overcome in terms of securing and maintaining employment. They're more likely to work in part-time, in lower paid and what are considered to be lower skilled roles. So they face disproportionate disadvantage and discrimination due to coronavirus. So occupation is an important factor in terms of increasing exposure to COVID-19. And some ethnic minority groups face greater infection rates because of the type of work that they do. So people from the Pakistani, Black African, Black Caribbean ethnic groups are overrepresented among key workers overall, and they face extra risk from greater contact with individuals who may be contagious. So we've seen commentators suggested that COVID-19 itself doesn't discriminate, but it exposes existing inequalities within society. Diamond, can you pick up on that point?
Yeah, so we've been talking quite a bit about gig economy, 0 hours contracts, precarious work. So I'm sure most of you remember some of the early days of the pandemic in sort of March, April, May last year, where there were queues at supermarkets. People were desperate to stock up. People thought that there might be shortages in the supermarkets. But think for a moment of the workers in the supermarkets. Perhaps, you or family members have a work in retail. And so the supermarkets suddenly had to sort of bring in extra people. There was an increase in the use of online grocery delivery firms. So some of them already in existence, like Ocado, others are new, like Getir is a new grocery delivery online company that delivers groceries by motorcycle. So we've seen there's been a massive increase in flexible work, 0 hours work, but that's also increased in addition because of the pandemic. And the pandemic has had a particular impact on those engaged in gig economy work. And it's shone a light on the precarious nature of gig economy employment. And we have in particular women, young people, and as we mentioned before, workers from certain ethnic minorities being overrepresented in gig economy work. The lack of basic employment rights, such as sick pay, mean that many people are forced to continue working. And as we've seen, women are hugely overrepresented in health and social care sector, in the childcare and education sector. And so those are jobs which have close proximity to others. Social distancing is harder. But women workers also bear the responsibility of their own childcare needs, looking after their own children. So all that places huge challenges in terms of individual health and well-being, but also in terms of ability to participate in the labour market once social distancing ends. So, for example, we have a sort of a perfect storm. If somebody is employed flexible or 0 hours contracts, But as has happened a lot of the time during lockdown, schools are closed or childcare provision is closed. That requires people to homeschool or to undertake more childcare, whilst not necessarily having the flexibility to take time off work and be paid for it. I want to say a little bit about sick pay. It's something that's mentioned quite a lot in the chat about the kind of rights that workers need. So in the UK, prior to the pandemic, there is a right that existed, the right to statutory sick pay. It's brought in by Parliament, and that's paid by the government, by the state, although it comes via the normal pay slip. But effectively, it's the government that's paying this. It's £96.35 a week, and that's payable to employees and also to workers. So in theory, 0 hours contract workers should be entitled to sick pay in theory. There's some qualifications. You have to be off sick for at least 4 days in a row. Okay, fine. But in order to be eligible for sick pay, you have to earn above a certain minimum. And that's, you have to earn more than £120 a week in a normal week before tax. That's known as the lower earnings limit. And you've got to notify your employer. But the Trade Union Congress calculated that almost 2 million people miss out on receiving sick pay when they're ill. That's mostly women, mostly people on flexible contracts such as 0 hours contracts, and that's because they earn below the lower earnings limit. If you're on 0 hours contract and you might work 10 hours one week, 25 hours the next, when you average out what your earnings are, it may well come below the £120 a week. So that means you're excluded from eligibility for sick pay. But even when people are eligible for sick pay, many people just simply could not survive on £96.35 a week if they've already got commitments, such as rent and utility bills, which were based on what they were earning before they were sick. So some people simply cannot afford to go off work because they can't afford to survive on sick pay levels. Lydia did some research about sick pay and COVID that was discussed in the House of Commons last year. Can you say a bit more about that, please?
Oh, thanks, Diamond. Yeah, I did some research with a small team that's at Kent, and we were partnered with Unison, which is the UK's largest trade union. And we wanted to find out about care workers' experiences at work during the first wave of the pandemic. So our research was one of the earliest research work around issues in the sector. And we gathered data from over 2,000 care workers who were working at more than 1,000 different care settings, so very widely spread. And they were in England. And over 90% of those respondents, those 2,000 workers, were women. And we know that a very high proportion of care workers' jobs are designed as 0 hours jobs, and they tend to be very low paid. And even when the jobs aren't formally 0 hours work, care workers experience fluctuations in their hours of work and a great deal of insecurity and uncertainty about their hours of work. And one of the features of the jobs, partly because of that, is that workers tend to leave within the first few months of taking the job because the work is really hard and the conditions are poor. So between 30 and 40% of workers leave their jobs in care after less than a year. So remember what I was saying earlier about entitlement to unfair dismissal protection, even if you are considered to be an employee. So if you recall, back in April and March of last year, COVID was really taking hold quickly within residential homes. And we found out that lack of sick pay was one of the key reasons for this. We found that 8 in 10 of those care workers said that they wouldn't receive wages if they needed to self-isolate because of COVID. Now, some of those workers may have been entitled to the £96 a week, but if we think that the level of earnings for a living wage is £400 a week, for workers who are very low earners, that have no savings, that have ongoing costs, families, rent, etc., They just cannot possibly manage with £96 for a week. And so this fear of real poverty was meaning that they weren't self-isolating. We also found that requests that they were making at work at that time for personal protective equipment were being ridiculed by employers because there was a lack of clarity about what their entitlements actually were, whether it was needed, whether there were requirements for them to have masks. If there was a requirement for them to wear masks and aprons, whose responsibility was it? Was it the government? Was it the managers? The managers had scarce supplies. They were keeping them locked in cupboards. Workers had to ask special permission. So they were sort of making their own makeshift masks. And this confusion about entitlement was coming right from the top of government. Care workers were identifying they didn't have enough paid hours in one job. And so many of them were working in 2 or 3 different care homes, and the workers themselves were saying that this was increasing the infection risk because they knew that they were moving between these settings, and they were worried because they didn't have access to masks and aprons. And they also were worried because the way their shifts were organised meant that they sometimes didn't even have time to wash their hands as regularly as they wanted to. And we found Black workers who responded to the survey were less likely to complain to their supervisors when they felt that the care was unsafe for them and their service users or residents, because they felt this extreme sense of insecurity. So it's thought that many of the workers who work in hospitality, in retail, in health and care, in many of those jobs where employment rights are harder to access or don't apply, workers were exposed to higher risks of COVID. And the ongoing effects of that are now that we are seeing higher proportions of those workers now suffering from a condition called long COVID because they came into contact with the virus. And so they have ongoing health problems. So Diamond, as someone who leads the employment law teaching and learning for undergraduates and postgraduates at Kent, can you tell us if your students have been learning about these sorts of issues in your modules?
Yeah, so say something about what does employment law look like in Kent, and or rather, what does it mean to adopt a critical approach to employment law at Kent, given that we are very much a critical law school? So what does it mean to study employment law at Kent? Well, this past year when I've been teaching employment law or labour law, and there's been so much disruption. So all the students are living in the middle of what we're studying. And in a way, that's a feature of the way we teach critically in Kent, in that we also acknowledge the law of everyday life. So I always ask people what their experience of paid work is, if they've had an experience of joining a trade union. And the kind of questions we talk about are some of the issues we've been talking about in today's webinar. What are the links between employment, your job, your health outcomes, your life expectancy? We ask questions about who is protected by the law. So the theory of how much has the law kept up to date, given that some of the laws we're looking at date from, or the original versions dated from the 18th or 19th century, when, as we mentioned, it's all about master and servant. That immediately gives you a sense of hierarchy. It sounds like something from Downton Abbey. Well, it was when it was first designed. But it does mean that as the way work has changed with new technology, employment law doesn't necessarily protect all the people it should protect. The law might not necessarily know how to respond to when it's an algorithm making a decision about which route you take to deliver a pizza or not, that you're not directly controlled by a boss anymore. Employment law in the past used to be based on the boss telling you what to do, and that sort of suggested you were part of the firm, you were an employee, rather than a self-employed person or a worker. So in the employment law course, we also look at questions of how are you able to access the law to seek redress if something goes wrong? And this is a theme that comes up in many of the courses and modules we study in law school, such as housing and land law, criminal law, which is to do with the right exists in theory on the statute books, but do you have to have been working for 2 years before you're able to claim unfair dismissal? What about race or gender discrimination? Do you have those rights from day one? We also locate the study of law governing work within broader contemporary issues. So today we've been exploring the rise of the gig economy, but we also locate the study of law governing work in the issues around changing gender roles, inequality, and as well as challenges such as the COVID-19 pandemic or economic crisis, when the economy is shifting away from certain kinds of industry to certain kinds of services. We also explore questions such as, what does it mean to say that work and the labour market is highly gendered and racialised? So that we've touched on a bit in this webinar, that there's a clustering or a sort of grouping together of certain categories of people by gender or by race or by age in certain kinds of jobs or certain sectors of the labour market, certain industries, certain service sectors. So basically what we find is that employment law is a space, is a location where society attempts to resolve questions about fairness, justice, human rights, economic efficiency, business, redistribution through the tax system, and social change. So that means we study not just what the law on the statute book says, but also how it operates in real life and how we might like it to be changed. So it's also sort of looking ahead to how one might want to reform employment law to fit more with ideas about what society might look like.
Thanks, Diamond. There were just a couple of points that have come up in the chat that I wanted to address before we close. The first was somebody asking a really interesting question about whether education issues explain racialization in the labour market and disadvantage to Black and ethnic minority workers. That's not the case. So Black and ethnic minority workers can be, and the research finds they can be extremely well qualified, but in jobs where those skills are not utilised. So something else is going on there. And we know from the data about achievements in school, for example, that ethnic minority children can be doing extraordinarily well in school. And yet as they get older, they face systemic disadvantage in the labour market. Similarly to women, when we talk about disadvantage in the labour market to women, the disadvantage is less there for younger women, but once women have reached an age where they are likely to have perhaps had children or to be thought that they would have children, it's as women get older that the disadvantage becomes more evident. Somebody asked about whether workers could bring claims if they were fired without cause and gain compensation where they're on 0 hours contracts. Unfortunately, that's not possible to do because it's not considered that they kind of actually have a job that they've lost. So the law doesn't recognize that because there's no firm promise between the worker and the employer. And somebody also asked about about discrimination against employees. And yes, there are protections against discrimination, but they are extraordinarily difficult to prove and they take a very long time to proceed through the courts. So that's another day we can look at that. So the takeaway points from the session is that even before the pandemic, UK employment law was really uneven, and employers have been designing jobs in ways which are more flexible, which also mean that the employers have fewer responsibilities in law to their workers. That leaves workers vulnerable. And so those vulnerabilities, for example, around sick pay, minimum wage, the right not to be unfairly dismissed, etc., shows that COVID-19 has exposed, like a wrecking ball, how these pre-existing inequalities really have an impact on people's life chances and indeed their health. So it shows us that the whole structure of employment law is in really urgent need of reform.
So just put up a slide there. If you want to find out more, here's some websites and links to short documentary and even a feature film that if you want to find out more about work in general, precarious work, all these links will be emailed to those who signed up for this webinar as well. And just a final point to let you know about next week's Summer of Law webinar on the 8th of July. It's about what does law have to do with social media, and it's being led by another Kent Law School academic, Dr. Will Embio, and a group of Kent Law students who've been working with Will on social media and the law. And as you can see, many of us take social media for granted. We share, we like content, but how much is that regulated by law? And this session is about how the law perhaps is playing catch up. It doesn't say a great deal about how these algorithms and machine learning tools work and how they're kind of directly and indirectly controlling us. So that's for next week. Just to final slide, it's links to find out more about Kent Law School and Kent University in general. Here's our Instagram, Twitter, Facebook, and the website. So nothing left to say except thank you so much for joining us today or signing up later on the YouTube page. Hope you've enjoyed it and sort of hope it's given you food for thought and thought some more about what kind of subjects you can study in a law degree, and especially how we approach those subjects in Kent Law School.
Thank you. Thanks for your feedback too. It's been great to have your input. Bye.
Bye.